Very good evening, all of you. Welcome to yet another session webinar today. A very nice, the most, the one of the best topics that we could even think of. So the topic for today is going to be roadblocks and impediments to successful resolution. Um, look forward to active participation by all the members. And I welcome Mr. Raghavendra, the lead speaker, and Mr. Shivaram Kumar, sir, DGM IOB, who's going to be the chief guest for the day. I welcome all of you, and over to introduction of the chief guest.
Good evening, ladies and gentlemen. I'm extremely glad to introduce our chief guest for the day, Sri Shivakumar, Shivarama Kumar, DGM Stress Asset of Indian Overseas Bank. Sir has illustrious career in the banking industry, and he was with the IOB for the past 26 years. He started off as a law officer, and he's right now the DGM of the Stress Asset Management Group of IOB. We look forward for an active insights from him, especially so in the case of a financial creditor who has to play a major role, and that too when it comes to a public sector bank. I'm sure all of us will be enlightened by the pearls of wisdom of Sri Shivrama Kumar, sir. Thank you so much, sir, for joining us, and over to you, sir.
Sorry for the interruption. Apologies. Before Mr. Shivaram Kumar sir can start his speech, can we have the IPNet video, the purpose, introduction, and initiatives, please? Okay, over to Shivaram Kumar sir. Sir, you can start your address. Sir, you are muted, sir. Sir, you are muted, sir. You'll have to unmute yourself.
Thank you, ma'am. Whether I'm audible now?
Absolutely.
Yes,
Whether I'm audible now?
Yes, you're
yes, sir. Yes, sir.
visible. Thank you.
Thank you so much. At the outset, let me thank all the organizers for inviting me to this webinar. Mr. Makija is a very known face in the insolvency professional circle. I used to interact with him, and I also thank you for the introduction given by Mr. Panikar. And this is a good topic that he has selected for discussion and deliberations. Now, coming to the point, now IBC has completed 8 years of its existence. Just like any other legislation in India, every legislation, irrespective of its age, it is going on, it is evolving. Even see the Surface Act, which has been enacted in 2002, even now after 22 years of its existence, new interpretations are coming. So like that, IBC also comparatively new legislation. So it is, I can say it is still in the evolving stage, because IBBI is taking active role in bringing so many amendments to the regulations and need-based regulations. So it is evolving, but the question is that when we are going or looking at Surface Act, its impact comparatively appears to be less, because if a borrower is mortgaging his property or some vacant land and the bank is selling it under Surface Act, its consequence or impact is lesser when compared to a resolution plan that is coming through IBC is. So that is the reason I think IBC has got more special and specific attention among the financial sector. Maybe the reason is that the stakeholders involved here are more. Because it has got far-reaching consequences, it has got the impact on the economy is far-reaching. and there is a critical role in reposing confidence in the prospective investors. I think these are some of the reasons, and there are so many other reasons why this particular IBC code or IBC or this code has got a specific attraction. So when coming to the topic that what are the challenges or impediments in implementation of resolution plan or for a successful resolution plan, there are so many reasons. Like in a cricket team or a soccer or a hockey team, if all the players work together, play together, only the team will give a resounding victory. Similarly, any organization or any legislation also where there are so many players are there, if all the players together they play and exhibit their role properly, I think it gives a spectacular result and resounding victory. So in IBC also there are so many agencies or instrumentalities like resolution professionals, COC, adjudicating authorities, successful resolution applicant. So these different agencies, every agency or every instrumentality has to play its role properly. Then only I think the resolution will be very attractive, successful, and gives a good result. So why it is all resolutions are not giving such a success, or it is not satisfying the more number of stakeholders? The reason is that somewhere something is lacking. So that is the basic issue why I think we are all now come to this platform to exchange our ideas. Where are the roadblocks or how to come out of these roadblocks? So I think even though it is not a blame game, or we cannot point out that a particular agency or a particular individual is the responsible or irresponsible for these things. But like in any other system, there are certain issues which maybe if we address properly, the success of resolution may be more attractive, more result oriented. So even though it is not a big research project where we are landing in not getting a proper resolution, or maybe it is something one research project and in-depth study is required. But broadly, out of my experience, whatever that I have come across, I just want to share some of these ideas. So basically, we have to see the impediments from the stage of commencement of insolvency resolution process. Even before commencement also certain issues are there. So that may not be of more relevant because our journey starts from the date of commencement of insolvency process. So once this any corporate debtor has been admitted for resolution process, from the date of this commencement, so this time period also starts 180 days or 270 days or 330 days. So to what extent we are reaching these goals, in how many of the resolutions we are able to, or the system is able to complete the this goal post within the 180 days or 270 days or the maximum 30 days. But the percentage is very less. So what are the factors? The factors what I see is that once any corporate debtor has been admitted for resolution process, the first break comes in admission of the claims. The first problem starts whether a particular claim is correct or not, whether it is a financial debt or not, or it is operational debt, whether a particular party is related party or is a financial creditor. So these are the basic issues that are coming forward before the resolution professional. So there are so many judgments given by various NCLTs, high courts and NCLATs, Honorable Supreme Court, saying that this is the criteria, or these are the broad guidelines where you have to consider a particular debt as a financial debt, and if it is not fitting here, it is not a financial debt, it is a operational debt. So in spite of that, even today, after so many judgments by different fora, still it is becoming a challenge for the resolution professional to classify a particular debt as a financial debt or operational debt. Ultimately, court or tribunal may give a clarification or may say that this is the financial debt or this is not a financial debt. So here one factor is that this classification itself is consuming lot of time. So then comes the related parties. Who are the related parties? Who are not related parties? So everybody has got their own interest to get admitted as a financial creditor. So many parties want to show that they have given some finance or their monetary interest is involved in this resolution or in the CD. So there another issue is coming related parties. Then comes a tricky situation where a particular judgment has created havoc. Like originally it was not there. Once this judgment has come, now this government dues and the tax authorities dues, a lot of claims are there. In some cases, it is happening like a retrospective effect. So this is another area where RPs are finding it difficult to admit a particular claim as operational debt or operational claim or not. So I think this is one area where I think some more clarity is required, or maybe we have to have some more research into that. In spite of this rainbow judgment, maybe government has to come out. I think IBA has already initiated a process to amend the regulations so that the judgment can be probably or the confusion created by the judgment can be come out of that, or we can overcome that. So this is one area. Then coming to once claims are admitted, then the question comes to COC. In COC, what is happening? Every bank has got their own interest. Every representative of COC want to get more benefit out of the resolution plan that is coming. But ultimately, what is happening when there is a clarity on which financial creditor is getting what, and once you have decided to take a particular decision, whether to dissent or assent the plan, the decision is not stopping there. In spite of your dissenting, and there are so many judgments saying that commercial wisdom is final. Still, the financial creditors who are dissenting again approaching NCLT or NCLAT and making certain this thing, creating some hurdle. Of course, that is their right. Nobody can deny. But the problem is that it is delaying the process. This is one of the roadblocks where either this side or that side, assenting creditors or dissenting creditors are approaching tribunals, and tribunals are taking a lot of time for various reasons in disposal of these applications. And again, the application disposed at one level being again challenged in the second level, third level. So this is this litigation process is taking a lot of time, and that is causing a big block in the resolution process. So probably there must be, of course, now IBA has come out with the code of conduct for COC, but this is only a moral code of conduct or ethical code of conduct. But ultimately, when somebody's interests are affected, naturally they are taking the route of litigation or establishing, or they want to find out the way to establish their claim. So I think this is one problem. I don't know what is the solution. Solution may be there must be some broad thinking among the members of the COC, and they should see that to the extent possible litigation has to be avoided, and we should respect the commercial wisdom, whether you dissent or assent. Once the decision is taken, or proper majority has come, we should accept the commercial wisdom of the COC. So there is no point in litigating the process again and causing a lot of undue delay. Then comes once this resolution plans are coming, then there are issues like first of all, the plan, when the resolution plan is given by the resolution applicant, he is getting proper information about the ins and outs of the company or the CD. What are there, what are not there, what is available, what is not available, plus minuses, what are the problems that are involved in the a particular CD in resolution. Still, once resolution plan is accepted and approved, accepted by COC and approved by NCLT, then in many cases, the successful resolution applicants are claiming that when we have given the plan, it was like this. Now, when we see companies like this, so they start disputing the or litigating the plan. They want to go back. There are cases where the resolution applicants they are unable to implement the plan for various reasons. So when they are giving the plan itself, they should have thorough information, whatever clarifications they can take from the resolution professional. They can study the information memorandum, they can study the RFRP. After taking all these things into consideration only, they should weigh their plan and go ahead. Once plan is approved, you cannot go back and say that no, I thought like this. This is the difficulty I'm facing. So this is another issue that actually causing problem in successful implementation of the plans. Then another aspect is that when they are giving the plans, they should have proper knowledge or information with regard to the equity that they are giving or the NCDs they are proposing to issue. So once this resolution plan is issued, approved by the NCLT, then the problems are coming that there is a problem in getting the SEBI approval for NCDs or approval in exiting the equity and reissuing of the equity, delisting of the shares and issuing of fresh shares. So this is another area where the implementation or successful resolution is not happening. Then other outside agencies are also causing the delay, like government authorities. When lease is there, when CD has taken a particular property on lease for 100 years or 99 years, if the CD failed and now there is a resolution plan, new party is coming into picture, then what is the problem in continuing the same lease? So I have got personal experience where the government authorities have cancelled the lease even when it is subsisting, and new resolution applicant is going to take over the unit and continue the lease. So here also this litigation is starting. So this is another area. Then when they want to implement the plan, or before that also the erstwhile board of directors or promoters are not cooperating, and there are so many applications filed under section 19(2) for direction to the erstwhile directors. But NCLT are passing orders or directions to the erstwhile directors to cooperate, but in many cases they are not cooperating. If they are not cooperating, there is no machinery to see that the NCLT order is implemented properly. There are so many instances where there is non-cooperation from local authorities, revenue authorities, and police authorities, which is causing in delay of the implementation of the resolution plan, or even before that, when RP want to consolidate claims or he want to prepare information memorandum, he is not getting proper support from the erstwhile CDs. This is another area. So like this, every stage, there are certain impediments. Then another issue, big issue is this ED attachment. There are so many cases where properties are attached by enforcement directorate and there is no clarity on the conflict that is arising out of the resolution plans or IBC and PMLA. Somewhere there shall be some clarity who has got priority. When ED attaches properties, no buyers are showing interest to purchase the properties or under liquidation, or resolution plans are also not coming. In spite of there being a protection under 32A, many prospective resolution applicants are showing reluctance to give plan because of the ED attachment. So ultimately, I think the purpose of ED attachment is also to realize the assets and see that it goes to the proper person or proper agency. It may be a bank, it may be somebody else. But in the process, if the value of the asset is deteriorating, then it is not beneficial to anybody, neither to ED, nor to banks, nor to the system. So there must be some necessity for coming to a proper conclusion on this. I think the better way is that let the properties be sold and the amount be deposited either with the court or under the control of some agency. Ultimately, when amount has to be distributed, where it has to be gone, that can be sent. But before that, if the value is deteriorating, that is not beneficial to anybody. So these are the some of the broad areas where I could come across and see which are causing roadblocks for a successful resolution. I think the next speakers, I think, will throw some light on this. And Makijaji is there. I think he will give his inputs also. That is what I just wanted to share. Thank you so much, madam.
May I request Dr. Makija sir to thank the chief guest, please?
Okay, thank you, Geeta ma'am. And I think we had a wonderful, opening remarks and the comments by our chief guest, Mr. T. Shivrama Kumar, the DGM of Indian Overseas Bank. I would really, mention this, that he has actually brought into focus the issues which are being, faced by not only by the COC, but also by the IPs. Particularly, I was very happy to hear that there are roadblocks not only because of, say, the ED attachments and all, but also because of the NCLT delays which are happening. I think these are certain issues which need to be addressed on a topmost priority. Because I remember, if you look at BLRC, what was the objective of IBC? The objective of IBC, and the word which comes to my mind is speed is the essence. Now, if we are talking about the speed, naturally the speed has to be there in all stages. Whether it is the approval by the COC, it has to be done, and we also must make sure it is already there in the code of conduct that the people who are decision takers must form part of the COC so that the decision making becomes faster. And secondly, of course, at the NCLT level, there are impediments. And of course, Mr. Raghavendra Rao is also there to highlight more impediments. So I'm not going to mention about anything else. But thank you so much, sir, for highlighting wonderful points for us. And it's an opening which you have given, which is a very thought-provoking. And I think Mr. Raghavendra Rao will carry it forward and come to micro points or the minor points which are there. Sir, as a deep appreciation of your joining today and taking your valuable time for this particular webinar, we are happy to present you a memento, which is already on the screen, sir, for joining us today as chief guest. This will definitely be given to you in a physical form by the local team, by Geeta ma'am and Mr. Ravichandran. Of course, he could not join right now, but please accept on our behalf, sir. This is our humble request.
Thank you. Thank you so much, sir.
Thank you. It was always a pleasure. And friends, now, can I request one more thing that if you can open videos, everyone is requested to please open videos, because the interaction is much, much better with the speaker and with the chief guest who have also already taken time. So friends, now it is over to Geeta ma'am. I think Geeta ma'am, we should have an introduction. Namrata ji is ready with that introduction. So
Yes, sir.
can we request her to play that introduction of IPNet at this stage?
Yes, sir.
Yeah, please go ahead.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field. From specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen, IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Okay, thank you, Namita, for running this. Friends, now we are waiting for the speaker, so I'll hand over the proceedings to Geeta ma'am for further proceedings now.
May I now request Suhasini madam to introduce the lead speaker for the day, please?
Yes, ma'am. Thank you. I'm pleased to introduce the lead speaker for today's topic, Mr. R. Raghavendran, who is an CA and also systems information system auditor, and he is also registered insolvency professional. Sir is All India 16th rank holder in CA examination. He was in employment with Shipping Corporation of India, and he is in practice since 1986 at Coimbatore. He is a qualified CISA professional, and he was past president of ISACA Coimbatore chapter, and he has represented Anpur, Malaysia, and they have also won the best small chapter award for Coimbatore chapter. And he is also a faculty for the ISA course conducted by ICAA. So, sir has handled around 9 assignments under CIRP as RP and 3 as liquidator. So, we look forward for your perspective on the subject, sir, on the topic. Thank you.
Good evening to all of you. Am I audible, madam, first?
Yes, sir.
Yes, sir,
Thank
you're
you.
audible.
Yeah, good evening to all of you. Thanks to the IPNet for inviting me for my presentation. Thanks to Mrs. Ashish Makija, sir. Thanks to our chief guest. Our chief guest has put it in proper perspective, the agenda for discussion today. We thank our chief guest for having given us an overall view of what is in store for us today for discussion. So, can I share my presentation, madam? Is it possible? Or can you share, Geeta, madam, my presentation?
You will be able to share, sir. Please go ahead and share.
I think I am not able to share.
Sir, you are one of the co-hosts, sir. You will be able to share.
Yeah. Is it visible? I have shared. Is it visible?
Sir,
Yes, sir,
you
it
have
is.
to open the PDF.
Sir, you have to open the PPT, sir.
I have opened the PDF in my system.
No,
It
sir,
is
not exactly, sir. It is the only the list that is being shown. Or you need any help, sir? Shall I share it?
Mr. Raghavendra, what I
Yeah.
suggested, what I suggest is unshare this, because what you are sharing is the folder. So just unshare it, share that exact file, sir. I mean, sometimes it happens. Or otherwise, Geeta ma'am can help you in sharing.
Geeta madam, can you share it, please?
Yes,
All
sir.
right.
Yes.
Okay. I think, friends, while it is being shared, I must tell you that IPNet is your organization, and I request, if you have not joined IPNet so far, please do it. The link for joining will be posted in the chat box. So please click that link. The joining is easier. It is absolutely free of cost for all IPs. Okay. Sorry, sir. You can go ahead now.
Yeah, today's point for discussion is the roadblocks and impediments to successful resolution. So, what is a successful resolution? In our understanding of successful resolution, a resolution, can you move the, I think screen is not shared.
Geeta ma'am, what you shared was PDF. Do you have the PPT? Because the PPT sharing will be much better because it will come full screen.
Mr. Raghavendra had shared only the PDF version, sir. So I will be able to share only this.
I can share the PPT, just a moment.
Yeah. Yeah, it is. We can, okay, but it is still in PDF actually. Anyway, it doesn't matter, sir. You go ahead.
Yeah, it is shared now. Is it visible?
Yes,
Yeah,
sir.
yeah.
Yes, sir. Visible, sir. Move on, sir. Move on,
It
sir.
is
Yes,
visible.
fine.
Okay. So, what is a successful resolution? A resolution that protects value and capital and meets the interest of all the stakeholders. So, when we say a resolution, it has to protect its value, the value of the CD in the company, value of the CD, and the interest of all the stakeholders need to be protected. And many a times, many disputes are oriented towards, many of the stakeholders have an opinion that the IBC is more in favor of financial creditors than the operational creditors. So, are we giving a balanced approach to all the stakeholders? That is one of the primary questions which has come up in many of the case laws, which we will highlight one or two case laws where these points were discussed. And of course, our legal luminary, Mr. Makija sir, is here, which we will complement as and when required. So, how the interest of all the stakeholders are balanced and how the value is protected and maximized. So that is what is the expectation in a successful resolution. So in a successful resolution, what constitutes? See, recently, IIM Ahmedabad has carried out a survey, study on the effectiveness of the resolution process. A CD which has gone through the resolution process is able to perform better because it has become leaner and meaner and the dead weight is gone. So post-resolution, they have done better. And the resolution process, the survey by the IIM shows the resolution process, most of the companies are satisfied with the resolution process. So on the cleaner side, the resolution gives a satisfactory result for a company to continue as a going concern. And that is on the positive side. And on the negative sides, we have certain basic things. There are problems. The problems are broadly classified, as our chief guest has stated, some roadblocks, some impediments. So what is the difference between a roadblock and an impediment? Basically, impediment means there are obstacles in the process which slows down the process. There are many, like our chief guest has presented, there are many litigations, lack of clarity of data, non-availability of assets, claims, counterclaims, etc., which results in these doubts need to be resolved, and in the process, it is getting delayed. However, with the team effort, we will be able to find out the solution. So these impediments are solvable, but through a team effort and with the assistance of all the stakeholders in the process. But what are the roadblocks? Roadblocks are where you need the assistance of a third party. For example, the government. For example, earlier, once it is admitted into CARP, withdrawal was not possible. So only by section 12A, we were able to arrive at a withdrawal and we are able to go out of the CARP. So it was a roadblock. Government came out with the legislation and removed that roadblock. There was frivolous applications. The government came with the legislation and improved the basic limit from 1 lakh to 1 crore and further brought in section 29A. And there were roadblocks for the MSMEs. A genuine difficulty. They have become NPA, but they are not able to take over the company. Company goes out of its hand. So they brought an amendment 240A where they have given benefit under 29A, C and H, they have given the benefit to the MSME. So these are all the roadblocks where the team members will not be able to solve, but outside us, a government, a monitoring authority, IBBI, by a change in legislation, they can come and solve it. So broadly, to put it in proper perspective, roadblock to be all those which we are not able to solve immediately with the available by pooling the resources, whereas impediments by pooling the resources, by joining our minds, by finding a legal assistance, we'll be able to get it from the impediments, remove the impediments. So this is broadly how the roadblocks and impediments we are trying to understand and present it in this presentation. Broadly, as our chief guest has presented, impediments are there in the entire process. I have tried to present a picture showing how it can be classified. The impediments are there in the pre-CARP also, during the CARP, and post-CARP in the implementation. In all the three stages, there are multiple impediments are there. And we will see some of the case laws which has come in as a rescue for us to address all these impediments. I have tried to highlight some of the major impediments due to restriction of time available. We are not discussing in detail. I have just given a checklist of some of the impediments. Some of the cases, genuine cases, and some of them are fabricated cases, where the promoter knows the CD is going to be in the CARP. They start creating, fabricating cases, disputes, so that CARP is not getting admitted. This happens in many of the Section 9 applications. In Section 9 application, when the applicant makes an application, he has to make sure he gives a notice to them, get the reply. So no disputes are there, then only it gets admitted. To avoid getting admitted, fabricated disputes. And in some of the cases where I have handled, one of the promoter has gone to the extent of making the CD cannot be taken over by any third party. How tactfully has done, the entire surrounding location of the factory were sold to all third parties. The factory is there, mill is there, but the entrance is to there is no entrance available. The total premises is totally landlocked. Without the concurrence of the third party, RP and the liquidator cannot enter the premises, COC and SEC cannot enter the premises. This was designed and created with the ulterior motive by the promoter. So we are fighting a legal battle there. Then there are certain proof-aid transactions. These proof-aid transactions, members are aware. All the members who are here, they are all aware. They have experienced. Everyone has got an experience of the proof-aid transaction. These transactions were created only to reduce the value of the CD, so that when third party takes over, the major chunk they will be able to promote, will be able to retain, and the others they will not be able to take it. Like as our chief guest stated, non-availability of information, updated statement, and the first part in all the small cases, we don't have a FAR, fixed asset register is not at all available. So how to take over the statutory registers, fixed assets, faulty information, non-availability of information, the stated asset as per the balance sheet are not physically available. Then wanton destruction of the asset, substitution of the asset. There will be a very big plant, but only the cover will be there. The inside copper cable and all the transmission inside, the sensitive parts, all of them are done. How do you know that? So wanton destruction, wanton substitution of assets, scrapping of the assets and tools. In some of the engineering companies, tools play a major role, but the tools are destroyed or removed or substituted with the lower tools. Then in the accounts, bogus deposits. See, in the case of fixed assets taking over, it is at least identifiable by the valuer. But in the case of current assets, so much of receivable, so much of deposits in the books, but physically you are not able. See, those current assets are charged to the secured financial creditor against which they have given the working capital loan. But once it is into the CARP, you are not able to recover any of them. So that is another area. Similarly, creation of a bogus liabilities. Then another biggest challenges is challenges in maintaining a going concern. Before it is entered into the CARP, promoter ensure they are not able to, the RP or IRP will not be able to continue the operations. Operations are stopped by various means and ways. For example, non-availability of worker, resignation. See, once into CARP, all the important people resign en masse. They don't cooperate. You are not able to continue. Then lack of confidence of the suppliers, lack of confidence of the customers, orders are stopped, cancelled. So all these are some of the impediments in the pre-CARP. How to address these impediments? The first part, non-availability, section 19(2) application, as our chief guest has presented. How to implement the order of section 19(2). Still they don't cooperate, right? So this is the position with regard to the pre-CARP cases. And during the CARP, we come across multiple scenarios where the impediments are brought in by many of the stakeholders. So conducting the CARP properly in accordance with the regulations, in accordance with the code, and seeking the support of all the stakeholders by itself poses a challenge. inability to continue the operation as a going concern. Where you are taking over a going concern, the biggest challenge is in the production side, they still continue to take instruction from the management, not from the IRP and RP. For example, I was IRP, RP for one of the boiler manufacturing company. There are 4 boilers which are under process. When CARP is setting, the 4 boilers need to be completed to be handed over to the customers. It was a very big challenge for us to complete it, to seek the cooperation, because IRP, RP, in majority of the cases, are either chartered accountant, cost accountants, advocates, or bankers. We do not have the technical knowledge. And we need to seek the help of the technical people and to continue the operation as a going concern. So this is another big impediment in this. We need to file Section 19(2) application not only against the promoter, but also against some of the key employees, technical employees. And I should thank MCLT that they gave an order specifically against the employees to provide the cooperation to the IRP and RP so that they could complete the process on hand. So with a lot of challenge, the production was completed. And another thing, you need to do a, what we call, reconciliation between the expectation of the operational side and the expectation of the COC. COC wants budgeting to be presented to them in advance so that they'll be able to sanction the CARP cost. But operation side, they are not used to preparing. Being the MSME, they are not used to preparing the budgeting. So bringing in budgeting and informing the COC, taking their approval for operation and implementing was a very big challenge. So these are some of the impediments. This impediment, how it could be overcome? It could be overcome only by making the COC to understand the technicalities of the issue. So we need to market our understanding, our thought process to the COC and also to the participating team. So the non-cooperation from promoters, management, employees need to be addressed to a lot of extent. And during the CARP, in one of the cases, management started operating the bank account without the approval of the RP. We had to file a case against the promoter and also the other bank where the current account is being operated against the bank and seek their cooperation. Now, an application we need to file it. Without the approval of the RP, management starts operating the accounts. So a part of investigating work need to be done along with it. And within the given short period of time, we need to prepare a IM. For IM, the basic requirement is a best possible information made available to the prospective applicants. To what extent the prospective applicants can rely on the IM, and to what extent COC and the RP committing themselves to the correctness of the information in the IM. Because any bidder, when he takes over the CD, he needs to know what is the assets available for them and what do they need for taking over the what in additional information they need. Now, whether all this information is available with you, that is a very big challenge. And even with all the disclaimers and the qualification you put in the IM, the successful resolution applicant files a case against the RP and the COC for some of the lack of due diligence, as pointed out by our chief guest also. The due diligence was not done by them, and they put the responsibility on the RP and the COC for the lack of information, or stating that, assuming that the nature of the asset is like that. They have got this. All these issues, case laws have come in, and ultimately, in the honorable NCLAT, in one of the cases, honorable NCLAT has upheld that information given in the IM has to be taken at its face value as is various condition. We'll look at the case law also for that. So there is another risk area where the RPs are going through, and it is an impediment. Of course, it can be sorted out. Then fabricated documents, misrepresentation of assets and liabilities, substitution of assets. And in the case of inventories, small tools, parts of plant and machinery, unauthorized removal, and non-availability of specific asset as per the valuation report. The physical assets not matching with the books of account, and non-confirmation of parties of receivables, deposits, incomplete information in IM. The bidders, when they evaluate the IM, their quote on the plan, for the plan, with so many disclaimers, when they give a resolution plan, when the RP has to evaluate whether the plan is in accordance with the code, section 32, all compliances. Can you get a conditional plan? What are the conditions they are putting in? Because you have stated a particular asset in the IM as so and so, I am giving the resolution value, and if that condition changes, my plan value will change like this. Can you accept that such a conditional plan? If you reject that conditional plan, who is responsible for that rejection? So acceptance and as well as rejection, you need to convince the COC about why you are rejecting a plan. You need to convince the COC why you are accepting the plan and presenting it to the COC. So non-matching of expectation between the creditors and the bidders. What are the expectations? Creditors' expectation is maximization of the values of the CD. How to maximize the value of the CD? By default, when a CD is into CARP, the value of the CD is brought down. Even if you look at the valuation of the assets, when the sanctioning the loan, what was the valuation? The same asset, when it's valued at the CARP, what is the valuation? A drastic reduction, 30 to 40% reduction easily is there. So the expectation of the creditor is how to maximize this, how to maximize value of the CD. And the expectation of the bidder is when it is in CARP, how low I can get it. So how to bring about the reconciliation between these two expectations? This is another big impediment because many of the resolutions fail irrespective of, in one of the major cases, I have brought up resolution plan for about 125 crores, but it was rejected by the COC. Reason being the expectation of the COC could not be matched with the bidders. Subsequently, it went into liquidation, but ultimately in the liquidation, they have realized much below what was there in the resolution plan value. But COC is also, they have their own impediments. They are not able to accept some of the position in the plan stage, and they are able to accept at a lower value when it is in the bidding at the liquidation stage. So how to address this? Rejection of the, when a plan, development of a plan. What is the difference between a plan and a settlement? Many of the bidders provide a plan as if it is settlement to the bankers. But plan is not a settlement. There is a difference between a resolution plan and one-time settlement with the bankers. Many of the aspirants present the plan as if it is only a OTS to the bank. So we need to educate them of what is the liquidation value, how you have to provide for other this one stakeholders, what is the priority, what is section 53, what is section 42, and what is section 32B, the rights of the dissenting stakeholders and rights of the operational creditors. What is the minimum they can get it? What is the priority to be given to them? So all these things we need to take into consideration, and there is a responsibility on the COC to say the plan is viable, technically viable and implementable. So specifically in the Form H and specifically the adjudicating authority question on this point specifically, whether the technical viability has been discussed in the COC, where it is recorded. So while drafting the minutes, while conducting the COC meeting, while drafting the minutes, we need to bring in all this here. So one of the implement is the technical and substantive factors, how to bring it to them to make it as a viable resolution plan. So challenges in the technical, financial, commercial viability of the proposal in the resolution plan, the settlement, difference between a settlement and the plan, how to bring it. So these are all some of the impediments. See, these are all a broad outlook I have given. If we are going to each one of them, there are so many, as our Makija pointed out, there are so many micro points. On the basis of micro points, there are so many case laws. All those case laws I have not gone into, but I have gone into some of the few case laws which shows some of the impediments where it is addressed by specific case laws. For example, where an application is made, I have made that application on the basis of the information memorandum, but the information memorandum lacks so and so, so and so, so and so. So they have made an application. The case is Deccan Value Investors LP and another versus Dinakar Venkata Subramaniam and another. In this civil appeal, it was decided in 6 March. You have to take it. What is the role of how to address that specific issue of information memorandum? See, Honorable Supreme Court in this case decided IM still contains a wrong information. It does not contain full and complete information, and hence a resolution plan has to be rejected. The assumption is that resolution applicant would submit the plan specifying the monetary amount, other obligation after in-depth analysis of the fiscal and commercial viability of the seat, pointing out the ambiguities or the lack of specific details. Post acceptance of the plan by the committee of creditor should be rejected except in an egregious case where data and facts are fudged or concealed. Except there is a fraud in presenting the data, just because the applicant has not done his due diligence. Because of that variation, you cannot say you can reject the resolution plan. It is held that the resolution plan as submitted by the SRA is approved by the Honorable Supreme Court. This is the case of Deccan Value Investors. In another case, to make the company CD as a going concern, when the RP took over the company, some of the projects are going on. For the pending projects, as the project is proceeding, the RP has made a payment of around 59 crores to the ongoing project. It was objected by the financial creditor. Now, whether such payment is it in accordance with the process code? This case came up in NCLT Hyderabad Tribunal. Sai Ramesh Kanupati RP of Gayatri project, and this was clearly held. Any payment made without the concurrence of without the approval of the COC cannot be decided by the adjudicating authority. Only the COC has got the authority to approve the payment. So this impediment is, see, why we are discussing about this case laws. When there are impediments are solvable. So we get the precedence we come to know about the precedents of the cases, what are all the things done. So by going through these case laws, we are able to take out, chart out our territory. When a situation comes to us in a similar fashion, how do we react? How do we document? How do we safeguard ourselves? One more thing, apart from this case laws, now it has a requirement has come in, then how are we going to protect ourselves from the disciplinary committee? It is, members are aware that today we are getting equal number of disciplinary cases similar to case laws. If we go to our IBBA portal, daily we are getting some reporting of disciplinary committee report. So we have started compiling the disciplinary committee cases also. Where are all the negatives for the in our operations? Where are all do we make the mistakes? Which are all the things we assume to be as correct is not held as correct by the monitoring authorities. So this is the area, this is an area of impediment in the implementation, in the conducting of the CIRP. What are all the impediments? And the principle of corporate democracy was held by the Tamil Law Appellate Tribunal Principal Bench, New Delhi, in the case of Yogesh Kelkar and RP of Anudan Properties. The major question that came up for consideration was where the RP, as alleged by the applicants, had failed in its duties in steering the CIRP on a procedurally correct manner, where the COC failed to apply its commercial wisdom in a proper manner, where the adjudicating authority had erred in approving a resolution plan of the SRE. So these three questions broadly covers about all the aspects what we are discussing so far. In conducting the CRP, whether RP is doing its job properly. Who is the another major stakeholder? COC. Where COC failed to apply its commercial wisdom. Whether the commercial wisdom of the COC can be questioned. So the democratic principles of determinative role of majority opinion in the decision making of the COC is very well established. So COC's decision, even if is the sole member COC, the COC decision has to be taken as a democratic commercial wisdom of the COC. When the resolution plan is approved by the COC with requisite majority, after holding two deliberations, the decision becomes a collective business decision. So this is a clear indication given, and insolvency resolution is indubitably distinct and unrelated to a scheme of compromise or arrangement contemplated under the Companies Act. So how the process is to be conducted properly. Now, what about the decision, commercial wisdom of the COC? It has been clearly held. There is only a limited review available to the adjudicating authority, and the commercial wisdom of the COC is supreme. So, major part overall is covered in this particular case. Covers your conducting of the COC, how to address the impediments during the COC. So, during the CIRP. So we have seen the environment which was prior to CIRP, an environment during the CIRP. Now, post CIRP, a successful resolution can be held as successful only when it is properly implemented. Where the implementation is not completed properly, then the resolution is not successful and it is back to the NCLT and goes to the liquidation. So a successful resolution, the success of the resolution is in its implementation. So we have seen before culminating into a resolution, what are all the challenges, impediments that are seen here? We have seen the impediments pre-CIRP, during CIRP, post-CIRP, in implementation. there are so many difficulties, impediments faced. The SRA, the failure of the SRA to implement the plan. Why? Major two reasons. One is withdrawal by the intended investor. SRA comes with the proposal, a resolution plan, taking somebody as an investor, or he himself is an investor if he's a wealthy guy. But where he brings in an investor, how to make him committed to the project has been a very challenging task for many of the successful resolution applicants. So, in many of the cases, when the perception differs from the time of applying for resolution plan at the time of implementation, the perception changes changes to the investor, between the proposer and the investor, and this results in what? Results in the plan not getting implemented properly. Then when the intended investor withdraws partially, the SRA is left in the lurch. He is not able to proceed further. How to bind the investor to the project is a very big challenge many of the SRAs are facing in the area. And implementation of resolution plan is not only with the investor. There are other resources which are available, need to be mobilized to bring the CD back into the operation. So that is another challenge. So inability to mobilize other resources, withdrawal by the intended investors are the major impediments faced by the SRA during the implementation. To whom it does affect? It affects the COC, because as per the plan, you would have given a specific payment schedule. The payment schedule is not honored. When the payment schedule is not honored, how to decide? This is another challenge to the COC, another challenge to the RP. And in many of the cases, OCs are not allocated the same amount of settlement as given to the financial creditor. That is a hard burn there. And as our chief guest correctly pointed out, many of the statutory authorities post CARP, they start raising additional claims, additional demand, making it not possible for the applicant to implement the resolution plan. One of the best case I can, so that is everybody aware. EB department, EB dues. EB dues is an operational due, and in the resolution plan, they provide a settlement at a particular percentage. So the entire amount is not paid. But when they go to the EB department to get a reconnection or a fresh connection, only when you pay the past dues, they give you the reconnection. So otherwise, what happens? You need to go to them again. You need to go to approach the High Court concern or NCLT concern, take an order. Only on presentation of a specific order, the reconnection is given. So this delays. This is a big impediment. Similarly, many of these operational area where you need to restart, for which where you need the consent of the statutory authorities, as rightly pointed out by our chief guest, such consents are not available. Although in theory, legally, that is to be given, the operating officials at the statutory authority level, they don't want to take the risk. And they direct the applicant to please get a specific order, specific court order for this reconnection, for this approval, for this endorsement. You get a specific order. So again, they are back to the legal battle. So this is another impediment in this, and this is to be addressed by the tactical nature by the applicant himself. This is one of the major areas in the implementation where challenges from the statutory authorities. Although it is legally held, the clean slate policy given by the Supreme Court, and this was actually a roadblock And our government has come up with section 32A specifically to address that roadblock. But the roadblock is now removed. In place of the roadblock, some impediments are coming. These impediments can be addressed only by all the stakeholders together by the due process of law. And the best example of force majeure is our COVID period. Many of the resolutions, plans, which were approved during the COVID, before COVID implementation, the force majeure clause had a very big problem in the implementation. Yes, Madam Geeta, Madam, you have some questions? Are you able to hear me? Geeta, Madam, you have any questions for me? Right. Am I audible to all of you?
Yes, you
Yes,
are
sir.
audible.
Yeah,
Yes, sir, audible.
Yeah, okay. So post CARP, it is proceeding. So these are all the areas, these are all the impediments. Some of the roadblocks have been converted into implements where we need to address each one of them. And I have taken out some of the implement post implementation. One of the case, as our chief guest pointed out, unsuccessful applicants, cases by unsuccessful applicants. Of course, now that has been set to rest by the order of the Honorable Supreme Court in ArcelorMittal cases versus Satish Kumar Gupta. And some of the cases like 25-8, eligibility conditions were not met properly. Now, without the ineligible person is given the approval for resolution plan, the plan has to be dropped. Valuation, claiming that for a low value, the plan is given. The CD is capable of getting better value. Many of the promoters, even after approval of resolution plan, have gone to the court, even up to Supreme Court, to state that the valuation not properly done. The eligibility criteria was not properly met. In the recent case, appellate tribunal principal bench, Business Park Town Towers A Buyers Association Faridabad versus Atul Kansal. So how to fix the eligibility criteria? Can you fix the eligibility criteria, different eligibility criteria for the flat buyers, different eligibility criteria for others? Whether the RP can state that the existing flat buyers cannot give a resolution plan. So all these were the issues which are addressed by this here. Then there are so many case laws where the statutory authorities, after approval of resolution plan, have filed the case demanding a different claim. Now all those have been addressed, and this is one of the case laws in High Court, Asian Color Coated Ispat Private Limited versus Ispat Limited versus Assistant Commissioner of CIT Income Tax, where it was clearly held 32A is upheld and a clean slate policy is given, and the department is made to understand. The statutory department is made to understand that prior CARP claims after approval of resolution plan cannot be claimed from the successful resolution applicant. So that is another case loss. Valuation report. In the case of NCLAT, Ramakrishna Forgings versus Ravindra Lonkar and others. See, I'm not going into each of the case laws in detail. Members are aware, all the members here, participating members are resolution professionals. They are all aware about the case laws. What I am trying to state here is, yes, these are all the impediments that are coming. These impediments were addressed through the process of law by taking it up to the concerned adjudicating authority, appellate authority, or up to the Supreme Court level. So there is a way out with the consent of all the stakeholders. Whether RP can go up to Supreme Court of his own, unless the COC supports him, RP cannot go up to Supreme Court. So going to the Supreme Court, it is to say is very easy. But how to go to the Supreme Court, take the process up to Supreme Court, get your resolution, get your answer. In my own personal case, one of the cases, I have taken it up to Supreme Court. This could be possible only with the help of the COC. COC supported me till the last. Of course, we have the legal support also. And thanks to our Makija ji. Now, we have the other cases. Some of the secured financial creditors, dissenting financial creditor, and other financial creditor claiming that the payment has to be as per the value of security interest in the assets of the CD. Where you have a charge over the assets of the CD, in the resolution plan, can you claim more than what is given as per the plan because I hold a better coverage in the asset which is charged to me? This was finally answered here in the Edelweiss asset reconstruction case versus Anil Jain. And our Makija ji can clarify me whether this has been upheld in the Supreme Court. I think this case is pending with the Supreme Court. But as per the stand today here, they cannot claim better value than what is given in the resolution plan, even when they hold a security value which is higher than what is the settlement provided in the resolution plan. So that is another area of impediment. See, impediments can come from where? Impediments can come from unsuccessful bidders, can come from promoters, can come from many of the operational creditors, can come from dissenting financial creditors, dissenting COC members. So all the stakeholders, it is possible impediments can come. And the failure of the SRA himself will be an impediment in the proper resolution. Then operational creditors claim. In the case of NCLAT, where any queries? Any queries, any questions people can.
Raghavendra sir, if you finish and then we can take up all the questions because there are certain questions that have been in the box. So
Okay,
once you say that you are complete, and then I will post all the questions to you, and then you can answer them.
Sure. So because there was chat that was coming up, I thought somebody was raising the question, right? So operational creditors not paid was a Balaji facility versus CA Ramchandra Dalam Chaudhary in company appeal in NCLAT. That was clearly settled. What is the entitlement of operational creditor? The liquidation value and what is the priority? 32B is held clearly. So these are all the solutions which are made available to for the various impediments. So this will give us a roadmap on the basis of which we can address all these impediments. So another case law in NCLT Mumbai bench, Darwin Platform Infrastructure versus Union Bank of India. Can the status of CD reflected as active non-compliant in the records of the MCA be reason for non-implementation of resolution plan? This is post-issue, post-CARP in implementation. Such questions, such cases is another impediment here. Pendency of litigation initiated by person or stakeholder, a justifiable ground for non-implementation. Again, it is a case law here. Invocation and encashment of performance bank guarantee furnished for resolution plan as per regulation 36B of the CRP regulation, is it legal and proper? Extension of timeline for implementation, is it allowable? In the event of non-extension of time for implementation of resolution plan, can CARP be restored? If the extension is not given, will it revert back to CARP or will it go to liquidation? So these are all the various questions, micro points, impediments that are coming in, which has to be addressed. Now, broadly, we have seen what are all the impediments. If you look at all these points, what we have discussed, these impediments can be addressed by a process of law properly. Only thing you need to take a legal recourse or other means. But there are certain roadblocks. How these roadblocks was addressed so far? The first roadblock in a resolution was before IBC, companies were creditors under control. It was under the control of the promoter. The first roadblock which was removed is it has brought debtors into control. And again, there were unscrupulous elements which were taking over the CD, continuing to take over the CD. Section 29A was brought in. It was after the IBC2, it was brought in only in 2017. After the unscrupulous amount where they wanted to have a backdoor entry, 29A was brought in. And in some of the genuine cases where the MSMEs want to go out of it, they were not able to do it. There was a roadblock. So section 12A was brought in for withdrawal. Now, how to address so many bidders? So section 25(2)H, eligibility conditions were brought in. Now, there were frivolous application of divorce for 1 lakh, 2 lakh, 5 lakh, 10 lakhs. Threshold limit is increased to 1 crore. Now, on the real estate side, home buyers, a total lot of people who have given their lifetime saving for the particular home, they lost their home, they lost their hope, and they were made. A solution was given. See, none of the other stakeholders can address this. It was a roadblock. The roadblock was addressed by the government by making the home buyers as a financial creditors and gave them a voting right, a say in the resolution plan. So they have got the right to conduct. They gave a say to them. They gave a voting right to them. Their requirement addressed. Then guarantors. Can the FC proceed against the guarantor? How to proceed against the guarantor? That was the first case addressed by me. State Bank of India versus V. Ramakrishnan. That was my case. Guarantors case is different from the CD. The moratorium doesn't apply on the guarantor. So that is which was a roadblock, was removed by the case. Reduction in voting percentage for approval of the plan approval. Earlier it was 75%, brought down to 66% to make the approval plan easier. At the same time, for withdrawal, they made it as a point 90%. Because when it is a withdrawal, it is not a 66%. So there was a heartburn for OCs. Who can solve that heartburn of the OCs? Only this was a roadblock. Only the government could solve. They brought in 32B, what is the minimum liquidation value? A guaranteed liquidation value of the OCs. And for the dissenting creditors. Commercial wisdom of COC. It is a paramount. So, clean slate policy was brought in properly. Then section 32A, ring fencing of the assets was brought in. When MSMEs, when they were really struggling, it is due to the genuine failure, not due to any fraud. To safeguard them from the NPA, so exemption 240A, 25(2)H exemption, interim finance providing. So these are all the broad roadblocks which was brought in by a monitoring authority by way of various legislation and amendments and instruction were brought in and these roadblocks were removed. So overall, I have covered what is a impediment and what is a roadblocks. So a bird's eye view we have discussed within the given time, and I am willing to take the questions. One Dr. Abhiman Singh has raised his hands. Sir,
Raghavendran sir, just a minute before we will take questions and open the floor for questions. Actually, I just wanted to share a few words. That is, I was really wondering when the topic was put out to find out what is going to be the difference between the roadblock and impediments. I was wondering what it is going to be, how is it different, and how each of the impediments would be addressed, and whether resolution is the only way that it can or there is any other way to solve an issue, or when what were the various phases where we would have impediments, and what are the areas where you will have load blocks and all that. Oh my God, all my questions got answered in this short presentation by you, and that was amazing. And now we open the floor for questions. There was one Vijay Kumar who has put in a lot of questions. I would ask him to. May I ask Mr. Vijay Kumar to unmute himself and share the questions? Mr. Vijay Kumar, sir?
Yeah.
Sir, I think you are muted.
Thank you very much for giving me an opportunity. No, I am unmuted. I am unmuted. Am I not audible?
Yeah, you are audible, sir.
Sir, you are audible.
Am I not audible?
Yes, sir, you are audible. We can hear you.
Yes, sir.
Sir, please go ahead, sir.
I have, yes, sir. I have some better experiences with the COC, which two cases I handled. The first case was COC with the operational members, with the operational data as the members. The second case was there were institutional members also. So I wanted to bring it to the attention of the chief guest also because of the institutional members who are involved as COC members. See, we are talking about impediments in terms of what we call it as a roadblocks because of NCLT delays, other issues. But the friction points also are there in dealing with the COC also. IBB has issued a facilitation letter very clearly in 2019, I think. I mean, I gave the link also. It has clearly demarcated the responsibilities of the COC and RP or IRP, wherever on various issues. But often there is a conflict of what is the role. We are the COC members, you have to listen to us. I also draw attention to the disciplinary action proceedings against one of the COC against one of the RPs, where IBP has clearly said the COC, the RP has to be independent also. And he has done very good job in the sense there was a only sole member of the COC. That sole member has not done proper job in lending, and it has advised, it has asked the RP to file a liquidation petition, which has refused. So that COC member has gone to IBB for disciplinary action, but IBB has stood behind the RP and clearly identified that in this case the RP has conducted the proceedings very well. That link also I given, sir. I just wanted to bring it to the attention of the chief guest because he was involved in the public financial institution, respectable public financial institution like IBB. So one of the things again which I wanted to pick up, sir, there was in the COC meeting, one of the COC member was contesting, why should I contribute? I don't want to contribute because the assets do not belong to, we are not funded the company directly. We have funded the promoters against the assets, we have funded the company against the personal guarantees of the promoters, whatever it is, but it's a lending given to the company. So they are not willing to contribute. And the COC also asked me, there are only two members. The lead member asked me to file a petition and I did the other member. I filed it. Then whatever stand it has taken is a difference in opinion. So it would have presented itself in the NCLT, but it did not present itself in the NCLT at all. Ultimately, NCLT has to pass the what do you call it as order without their presence. So, responsible finance institutions, why should they waste the time of the NCLT by not attending the CO before the NCLT? They may have differences of opinions with the RPs. They may be right also with the commercial wisdom, but they should represent when the issue is stated before the NCLT. They should represent themselves, but they are not done. In a way, is irresponsibility on the part of the public financial institution concerned. So that's the one issue which I wanted to say. Another issue is because there is a order against the CD for cooperation. CD has to cooperate with the RP, but CD has not cooperated, dodging. Then the lead member also suggested I should take action. Then I filed contempt petition. Then the COC member got scared. Why do you file contempt petition? That's the only option which has left to me. Still, it was not done. The contempt petition was to be removed. I was removed. I filed a contempt petition at the CD for not filing, for not cooperating. The third various levels of officers. So they may have difference of opinion, but their action should cloud the decisions. The COC at liberty to remove. At the same time, let there be internal procedure where it is escalated to the next level of the officer representing in the COC. That will be in the fairness of the justice, and that will reduce the friction levels between the COC and RP. IPS. So this wanted to bring it to the attention of the chief guest also, sir. Thank you.
Mr. Raghavan, sir, you would like to answer this question, sir?
Sorry, our friend has addressed this chief guest, sir. So I would refrain from answering this question. Rather, I would divert this question to our chief guest, sir.
Okay.
Okay. I will take that question. See, I am not specifying that. I made it clear. It is not one particular agency whose conduct is the reason for delay of the process. It may be COC. It can be, as Makija sir told, that in NCLT, so many resolution plans approved by COCs are pending, ranging from 6 months to 2 years, 3 years. So everybody has to take it forward, not only the COC, not only RP. So everybody, the ultimate motive is that everybody's job should be done diligently. Then only successful resolution will come. That is the idea. Everybody's part, everybody's role, they have to play properly. Whether it is a COC member or maybe RP, IRP, or even we cannot comment on tribunals, but tribunals also so many are pending. So that is causing delay. That is the point. I am not protecting that COC, everything is good or everything is sacrosanct there.
Okay,
Right, sir, Vijay Kumar, sir.
Yeah. I think, sir, the point what Mr. Vijay Kumar mentioned was naturally the COC's cooperation is also required, because one of the aspect is not sharing the CIRP cost also. That is also one of the issues, because without that, the CIRP process cannot go. I think we have very fairly discussed the entire subject here. So, Geeta ma'am, do you have any other questions? So we can move on to the next question quickly.
See, Makija sir had himself raised a question on the contribution of the CRP cost is definitely an issue. Is there a, what is the solution? So, Raghavendran sir, you would like to take this question?
Yes. CRP cost, COC members have to pay it in advance. And of course, it is returnable to them. When the plan is approved, it is returnable to them as part of the plan disbursement. And also, it is a priority under 53(1)(a). But still, in the cash flow, getting the CRP cost paid in advance is a very big challenge, and we need to do a lot of convincing to the COC members of the need for make them pay, especially when cases where only operational creditors in the, at least bankers to a certain extent, they understand what is a COC, what is a CRP cost. When operational creditors are there in the COC, they constitute the COC. it is almost next to impossible to get the CRP cost from them. So only when you get a successful resolution plan, or only when you are able to sell the assets, you are able to recover the CR, because the present day environment, it is really challenging. But I should thank some of the bankers are cooperating. Some of the banks are giving. Yes, madam, you can go ahead. Next question, madam.
Now we can, the members present in the forum can raise their questions, because there were only 2-3 questions in the chat box that has been addressed. Mr. Rajesh Kurup, you had some suggestions. Can you please unmute yourself and share your views? So according to him, he says oftentimes it is perverted exercise of so-called commercial wisdom by COC. That was his comment. So just wanted to know what made him write that, and whether he has anything to share.
Dr. Abhiman Singh also had some question.
Yes, he's there. So Dr. Abhiman, sir. Dr. Abhiman Singh. He was there. I think he is unmuted. He's muted himself. So any other questions, please? Makija sir, would you like to add to the topic of the day some few things that what you as a
See, as a legal counsel, I can simply advise the COC people, also COC particularly, that whenever they are coming to the COC meeting, they should send an officer who has got power to take decisions on the spot. What we have seen in most of the cases is that the decisions are deferred, and the officers who are attending, they typically say that we have to go back to the head office and take their approval, which is fine to a certain extent, but sometimes they seek so many extensions that they would like to, you see, initially they talk about 2 days, then it becomes, 7 days, and then becomes 14 days. So I think that early decisions will definitely help. We can understand that there is a hierarchy in banks, and naturally one would like to take responsibility, but that is one other need of the day. That is one. Number two, the importance is that the COC members and RPs will have to coordinate with each other and understand each other's problems. The issue is that IPs will always typically raise, oh, the COC is not cooperating, the payments are not being made. Be that as it may, still, if we are able to explain the things properly to the COC, I don't think those impediments will be there. So those impediments can be sorted out. But the systemic impediments which are there, particularly NCLTs, the roadblocks are typically where the plans are not getting approved for such a long time. I think that is a major concern for the government actually to look into those aspects. So Mr. Shankar Panikar is also there. Let's have a final comment from him before we wind up. So, or anyone has a comment, I think we can have a discussion.
I thank you, Dr. Makija. You have simply articulated well. See, what happens in success of CRP, there is a dichotomy according to me. Whatever word we use, according to the limited cases or whatever we have seen here, end of the day, whatever word we use, back of the mind, especially so in the case of a banker, he wants to get the maximum money, and then least bothered about the other factors, other stakeholders. So, for example, in the case of a case where bankers have a claim, and it is a case where under Section 10, they have said we will not ratify the expenses. They will not do that. So, okay, let us assume that since it is a Section 10 application, to a certain extent, it is not triggered by them. So therefore, they are okay with claiming, but they are not okay with ratifying. Similarly, I've seen a lot of cases where there is literally a stoppage of CIRP, or sorry, the process when it comes to non-indecisiveness of COC, indecisiveness COC. So what is the way out? Way out is clear-cut, action plan or clear guidelines which they have to follow. And in the COC meeting, there has to be a checklist where the COC has performed their duties. When it is very clear that under section 34, subsection 4, that they have to exercise their feasibility and viability, it has to be a speaking. Now what happens is, end of the day, when a resolution gets passed, there are a lot of cases before appellate tribunals and Supreme Court whether their commercial wisdom is interpreted in such a way that, look, they have not exercised it. So there has to be some sort of objectiveness in the matter of conduct of COC. Another factor, impediments and roadblocks, is how this government regulators, I'm just talking from the perspective of post-resolution plan, and the regulators who think they are above God, they will never place the claim. And they really don't know what is IBC. They'll never bothered. In one of the cases where we have handled the counter affidavit, they say that the newspaper advertisement, that particular newspaper, we are not subscribing to. We are not subscribing to that particular newspaper in which the public announcement has come. So we are not held responsible. This sort of irresponsible thing. So therefore, there has to be a dialogue between government regulators and IBBI, because IBBI has been given the mandate to spread this thing. Of course, as organization like us, where IPNet and other IPF and other bodies, we can definitely play a big role. But end of the day, when we speak, it is end of the day, it is just speaking from the perspective of IP alone. But a regulator has to speak to another regulator. For example, in the customs department or GST department, they've got a specific cell who will take care of the claims, or they will lodge the claim within such and such state. Especially so in the case of a state jurisdiction, revenue records or something. After the successful resolution applicant, after taking a lot of risk when he buys or certain assets of the insolvent company, he has to face such things. So that is something which, but it is evolving. Good thing is it is evolving. In one of the cases where the NCLT Kochi has given a speaking order, very speaking order to a municipal, village, municipality, saying that you please don't teach us. This is what you are supposed to lodge a claim, and if you have not done it, then it is your responsibility. So it is evolving, but end of the day, according to simply one word, one sentence is, there has to be a code of conduct for committee of creditors, and written code of conduct, and it has to be implemented, and there has to be a specific written, speaking minutes, and of course a dialogue, a meeting with regulators too. Thank you so much.
Any other questions?
I think, Geeta ma'am, we can conclude now.
Good evening, all. May I just add some points to what Mr. Kurup has suggested regarding the intimations to the government departments. I feel that there should be some mechanism wherein, say, once the NCLT pronounces a judgment declaring CIRP, it should be escalated to a body like apex body like a IBBI also, which in turn should communicate to all the government departments in the particular state where the CD's registered office is situated, so that all the government departments are intimated and everybody can raise a claim. It is true that they say we cannot expect that all the creditors will read all the newspapers. Say generally we IPs go for say small newspapers where the cost of advertising is very effective or very less. So even that is the expectation of the COC also, to reduce the expenditure. So that's why we put in the paper where the circulation is mega or which is not very well circulated among the general public. So I feel that better we adopt such a way that one apex bodies intimates a notice of CIRP to all the government departments. But in my case, I write to all the government departments, which I presume that, which I feel that they may be involved in this particular, or they may be a creditor, there may be some juice. Of course, might not be. It is my duty to inform to the government departments like IT or GST or profession tax or some other departments. These are my views.
Thank you, sir. As we don't foresee any questions, it is for the announcement for the next webinar by Mr. Rajiv Kumar Agarwal.
Good evening, everyone. I am excited to share details about our upcoming webinar titled Regulatory Compliance of Insolvency Professional for IBBI and IPA. This informative session is scheduled for October 26, 2024 from 4 p.m. to 6 p.m. We are privileged to have Advocate Mr. Arun Gupta as our keynote speaker, with Mr. Mahesh Gupta, IPNet member, serving as the coordinator. We eagerly anticipate your participation. Thank you. Thanks a lot.
We thank all the members for the active participation. First of all, let me thank Mr. Raghavendra for such an insightful presentation and giving us a lot of food for thought. And thank you so much, sir. And thank you, the chief guest, Mr. Shivakumar, sir, for opening for a big, good, nice opening that you made at the beginning of this webinar. And Raghavendran sir for continuing the momentum and keeping it tight and very, very informative speech. And Makija sir for the thoughtful note by him. And this is a certificate of appreciation for Mr. Raghavendran for the outstanding contribution as a lead speaker for today. And this will be reached to you, sir, in person very shortly. Thank you all for participation, and we look forward to your continuous participation and learning from IPNet website. Thank you and good evening.